The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Hi, I'm Kevin O'Flaherty. I hope you enjoyed this Learn About Law video and podcast presented by O'Flaherty Law. If you need some help, please feel free to give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have several locations for your convenience. Thank you so much for watching and listening.
Hi, this is Andrew with Learn About Law, and in today's video we'll be discussing joint wills and answering questions like, what is a joint will, why and when would someone get a joint will, and how do I get a joint will? So estate planning can feel like a daunting task, especially when trying to do research on your own without a qualified professional to lead you. And often it's really not something we even think about until we've started to amass a certain amount of assets or have more responsibility, usually in the form of children. So when a married couple starts to think about what might happen to their assets if one or the other unexpectedly dies, they may come across what's called a joint will when doing research. So a joint will is essentially a single will shared between two people, typically spouses. The joint will entitles one spouse to inherit the entire estate upon the death of the other spouse. So when put simply, it sounds pretty good, like a good option and less work since it is one document for two people. However, there's a lot to consider when planning for the future, and a joint will is actually most likely not the best option. So again, what exactly is a joint will? So a joint will is a single document jointly signed by two or more individuals, which combines the parties' last will and testament. With a joint will, the surviving party will inherit the entire estate, and after the death of the surviving party, the estate will be transferred to the children. So beyond just covering more than one person under one will, the joint will also acts as a binding contract that prohibits the participants from making changes to the will after the others die. You may be thinking, well, this is what we both want. We want the same thing. But things can change with time and often do. The survivor being beholden to any agreements made under the joint will can lead to some messy legal ramifications later on. So what are some negatives of a joint will? Well, while the legality of a joint will can still be contested in Illinois, having your hands tied by a joint will after marriage can certainly create a number of potential problems, including things like you or your spouse die relatively young, you get remarried, but the joint will with your ex-spouse limits your ability to include your new spouse, children, or etc. into the existing will or maybe a new trust. An issue with the child arises and continues past the death of one spouse, so the options available regarding changing inheritance for that child are going to be restricted due to that joint will. The joint will can interfere with the surviving party's wish to help grandchildren with college expenses or give out an early inheritance. If a piece of property is listed under the joint will, it could be restricted from being sold or rented by the surviving spouse under the language of the joint will. Or if a child is irresponsible with his or her money and spends in an extravagant way, the surviving spouse can't change the joint will to limit funds available to that child. So again, joint wills are considered generally like relics of estate planning. The number of cons associated with joint wills greatly outweighs the benefits, especially when compared to other estate planning tools. While the law may vary from state to state with regard to enforcement of the articles laid out in a joint will, Illinois seems to allow for some flexibility with regard to challenging the language of a joint will. So for example, if the joint will did not use explicit language regarding inheritance or some other topic, and this is challenged by the surviving party, he or she may win the ability to move forward with whatever action they're seeking. However, when the provisions of the will are reciprocal, and this is normal in the case of mutual wills, which are different from standard joint wills, and it appears that the provisions were made in consideration of each other, the will becomes a joint and mutual will and enforceable as a contract. A joint and mutual will may become irrevocable after death, especially if evidence shows that provisions in the will were made in consideration and upon explicit agreement between the parties. So bottom line, pretty much any estate planning professional will steer you away from a joint will just because of all the inherent negatives associated with this type of plan. The convenience of having one will between two or more people and the possibility to save a little money will be greatly outweighed by the potential headaches that could arise from a joint will. For more information on estate planning tools, check out our other videos on Learn About Law. Thanks for tuning in.
Hi, Kevin O'Flaherty again from O'Flaherty Law. Hope you enjoyed our presentation of Learn About Law. If you need some help, please feel free to give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have several geographic locations for your convenience. If you found this helpful, we'd love it if you'd subscribe to us on YouTube, SoundCloud, Apple Podcasts, or wherever you listen to your podcasts or watch your videos. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.